Good morning. Today is Thursday, October 2nd, 2025, and we're on record with the Grant County Board of Equalization, and we'll be hearing petition number 2024-190 for parcel 39461-141218000, represented by Derek and Jessica Jenkins, who are not in attendance. The assessor's office is represented by Clayton Johnson, who is in attendance. Please silence your cell phones and note these hearings are being recorded and will be posted to YouTube once the order has been issued. Mr. Chair, the board is convened and the hearing is open.
The hearing today is regarding the true and fair value set by the Grant County Assessor's Office. Reminder, this relates to your assessed value of your property, not your property taxes. Board of Equalization is independent of the Assessor's Office. We are 3 citizens appointed by the Grant County Commissioners and trained by the Department of Revenue. Today's board is comprised of myself, Jim Breakville as chair, Marge Steinmetz as vice chair, Jerry Gingrich is a member, and we also have Rosa Decker in the audience as a member, a non-voting member today. We have reviewed all evidence presented by both parties. The hearing is only to present any additional oral testimony. No new evidence may be submitted at this time. Remember, everyone's time is valuable. Please try to keep to the timelines. Please address the board only. Since there's no appellant, does the assessor's representative swear the testimony you're about to give is the truth?
Yes.
Go ahead.
All right. This subject is a 1,369 square foot single family residence on a 6,000 square foot residential lot in Ephrata. Page 6 is sales used for market adjustments of the subject property. Page 7 is sales comparison grid that shows an average adjusted market value of $236,804. Therefore, we are asking the board to sustain our current assessed value at land $20,000, building $192,689 for a total assessed value of $212,689.
Questions? Mark?
No.
Okay. I think we'll just go ahead and roll into the next one. So go ahead and close this one out.
Okay, next we will be hearing petition number 2024-196 for parcel 39032-141015001, represented by Hendrik and Sonia Bentham, who are not in attendance. The assessor's office is represented by Clayton Johnson, who is in attendance. Reminder that Clayton, you are under oath still.
Yes.
Go ahead when you're ready.
All right. This subject is a 2,192 square foot duplex on a 3,914 square foot residential lot in Ephrata. Page 6 is the sales comparison grid showing the sales of comparables in the subject neighborhood. That comparison grid shows an adjusted market value of average of $365,667. Therefore, we're asking, on this one, we're asking the board to adjust the current assessed value. Land value $15,875, building $349,125 for a total assessed value of $365,000.
Question? Board?
No.
Okay.
Moving on to the next one. We are here to consider petition number 2024-207 for parcel 40015-141347417, represented by Brock Salzman, who is not in attendance. The assessor's office is represented by Clayton Johnson, who is in attendance. Once again, reminder, Mr. Johnson, you are under oath.
Yes. This subject is a 1,283 square foot single family residence on a 2,682 square foot lot in Crescent Bar. Page 5 is the sales used for adjustments in the subject neighborhood. Page 6 will show the sales comparison grid showing an average adjusted market value of $531,455. The appellant stated that their property has all the original construction and nothing has been replaced, and in order to sell near market price, they would have to make upgrades. The comparable sales in the above grid have the same condition and quality as the subject and indicate a market value higher than the subject. The recommended repairs that are listed on the petition appear to be typical wear and tear that has been accounted for in the effective ages of the subject as well as the comparable sales. The appellant also states issues with the HOA. However, that does not appear to have an effect on the market as shown in the sales. With that, we're asking the board to sustain the current assessed value at land, $125,000, building, $283,540, for a total assessed value of $408,540.
Moving to the next one. Petition number 2024-210 for parcel 24118-101-009000, represented by Crab Creek Homestead, who is not in attendance. The assessor's office is represented by Clayton Johnson, who is in attendance. Mr. Johnson, you are still under oath.
Yes. So this subject is a 12,972 square foot vacant residential lot in Moses Lake. On page 6, you'll see the sales of vacant residential land in the surrounding areas. The subject is currently valued at $2.72 per square foot. The appellant states that parcel 10-1008-00 is next to this lot and about the same size and is valued at $24,010. That parcel is smaller than the subject and was receiving an additional adjustment in error that the subject was not. That adjustment will be removed moving forward. The subject is receiving a negative adjustment to account for the abnormal topography and unpaved road. Therefore, we're asking the board to sustain the current assessed value at land, $35,260, building, 0, for a total assessed value of $35,260.
Okay.
Next, we have petition number 2024-211 for parcel number 24119-101-010-000, represented by Crab Creek Homestead, LLC, who is not in attendance. The assessor's office is represented by Clayton Johnson, who is in attendance. A reminder once again, Mr. Johnson, you are under oath.
Yes. This subject is a 13,068 square foot vacant residential lot in Moses Lake. Again, page 6 shows the sales. This subject is currently valued at $2.70 per square foot. The appellant stated the same thing on this one. The lot next to it is about the same size and valued at $24,010. That parcel is smaller than the subject and was receiving an additional adjustment in error that the subject was not. The subject is also, receiving a negative adjustment to account for the abnormal topography and unpaved road. Therefore, we're asking the board to sustain the current assessed value at land, $35,260, building, 0, for a total assessed value of $35,260.
Sure. Mark?
No.
Okay.
Is it? Ready to pause? We are
Well,
pausing.
we probably should close it.
Close it completely
I would say so.
until 10:40.
Yeah.
Okay.
You're done. I
Sorry, I apologize. This concludes the Grant County Board of Equalization hearing. The board will review all the information provided and board orders stating their decision will be issued within 45 days. If either party disagrees with the board's decision, they may appeal to the Washington State Board of Tax Appeals within 30 days of the mailing of this. We will recess until 10. You are online.
In essence, they were removed from current use, and they said that you said it's all a big mistake, and that if the board agreed that, yes, you agreed, they should be put back in. And
I
I think
blame
it's on
you.
the third page.
Yes.
They blame you for not giving them the correct information.
So we're just trying to-
Mr. Pope.
Mr. Pope, yeah, Matthew Pope.
Quiet.
CRP contract. Now I'm remembering.
Glad we're on the record for that.
Okay, so
Before you start, let me read the information into the record as to what
Yep.
it is.
yep.
You've got
Oh,
everything.
I've got your
Yeah.
information that you read.
You've got everything, yeah. Okay, this is the parcel number 150699000, Thomas G. Sokol as taxpayer, and the Marie Rashko is the name of the agent. We're talking about the good cause waiver, and we're talking to Assessor Matt Hope. So tell us what your input is on this. I mean, they're basically, from what I'm reading, they're blaming you for not giving them all the information, which,
Okay, and this was a long and drawn out process. When the property transferred after the passing of Mr. Sokol, they were in the current use program. A request was sent out to gather information. There was no CRP provided for CRP program that covered the legal descripted area in question, the parcel. When you get a CRP contract, there's areas that it covers. It did not cover the parcel in question, which is what initiated the removal from current use. Now, I was contacted by a couple of different people concerning this, and I let them know if there in fact was a current or a CRP contract that covered this area, that they would need to supply that to us because they had received notice. Now, there was a statement made in the packet as I was reading through that stated that they hadn't been given any timelines. The request to remove or the intent to remove lays out timelines. There is specific timelines in that request or intent to remove. And so I don't believe that that is accurate. What I did tell them is that we needed to get that information and they needed to contact Amy, who handles the current use, and get the information to our office that does cover that. Because if it still was in CRP, then it could remain in the program. Now, to my knowledge, our office still to this day has not received that information. I don't know that for a fact. I haven't followed up because I didn't, I put them in contact with Amy. I can follow up with Amy to see if she's received anything based on that CRP to cover that area. But I know that was the reason the removal was done, because the CRP contract that we had, they had one that expired. They let us know that they had one, but we were never presented with a CRP contract that covered that parcel in particular. So that was the reason for it being removed from the current use program. And so I did have communication with a couple of different people concerning this and informed them of what our office needed to either stop the removal process or continue based on whether or not it was included in the contract. And so again, to the best of my knowledge, our office still hasn't received that, but I don't know, and I can't say with perfect knowledge that we haven't. I know I have not seen that CRP contract, but Amy may have.
Would that be something that you could possibly get us this morning?
Yes, yeah,
Okay.
yep, most definitely.
All right.
I can, in fact, what are we at for time? Yeah, I can run back and see if Amy has received anything and be back momentarily.
Do you have any questions?
Not at this point.
I didn't get a chance to read far enough in the packet to see if they supplied the contract with the evidence that the information provided in that late filing.
I didn't see anything.
I'll let you look for it. You know more what you were looking for.
But that would be the main concern throughout this entire process was the need for proof that the parcel still qualified for the current use program.
You know, in addition, if it's in there and they haven't supplied it to you, then it's still a moot point, I think, at this point.
Yeah, keep it in mind, this is just a late filing good cause waiver.
Right.
They would still have to go to a hearing and everything else.
Right.
We're just debating whether it has a good cause.
Yep. And what, I didn't even check what their reason, their good cause reason was.
Second page.
Second page, okay. USDA.
C.
Yeah.
Okay, so we do have a CRP contract here. So I would have to. Okay.
Second page C.
And as I understand it, when it comes to a current use removal, it doesn't fall under the same, because that value, because it is a change in value, they have 30 days from the intent to remove, 30 days from the change in their taxable value. So they may not have even needed to file a good cause late filing. I don't know if it met that requirements, but this is saying that they were unable to because they relied on incorrect or misleading advice. So it does look like we have a contract here. I'd have to review it to see if it does in fact cover that area that, that's in question, the parcel in question, because it's got, section laid out rather than any parcel numbers. Looks like section 20.
Do we need that? Can he,
Trust him.
do we trust him?
That's a question I can't answer.
I'm thinking, go ahead and take that and see if you can come up with an answer and bring it back.
Okay.
We'll be here until at least 12:20.
Yep, and I'll be in the 12 o'clock hearing as will Amy. So
Okay.
if you would like, we can be here a little earlier and discuss this portion of it with Amy before the hearing, if that works.
That works too. Yeah, okay.
All right, wonderful. I will,
At this point, we'll go ahead and go off the record.
Good morning. Today is Thursday, October 2nd, 2025, and we're on record with the Grant County Board of Equalization, and we'll be hearing petition number 2024-213 for parcel number 4439-021-086-000, represented by Gina Costello, who is in attendance. The assessor's office is represented by Clayton Johnson, who is also in attendance. Please silence your cell phones. Note that these hearings are being recorded and will be posted to YouTube once the order has been issued. Mr. Chair, the board is convened and the hearing is open.
The hearing today is regarding the true and fair value set by the Grant County Assessor's Office. Reminder, this relates to the assessed value of property. Does not, not your property taxes, let's put it that way. Board of Equalization is independent of the Assessor's Office. We are 3 citizens appointed by the Grant County Commissioners and trained by the Department of Revenue. Today's board is myself, Jim Breakville as chair, Mark Steinmetz as vice chair, Jerry Bush as a member. We also have Rosa Decker in the audience as an observer today. We reviewed all evidence presented by both parties. This hearing is to provide any additional oral testimony. No new evidence may be submitted at this time. Remember, everyone's time is valuable. Please try to keep to the timelines. Please address the board only, and do both the appellant and the assessor's representative swear the testimony you're about to give is the truth?
Yes.
Are you both going to testify?
Yeah,
Okay.
she is.
All right, just you. Okay. And the appellant goes first, so go ahead.
Okay, so the reason I'm here is because I think the assessed value is incorrect. I inserted a note also from a realtor who's been a realtor and DA for a long time. And what they're doing comps for me is the most desired area, Lakeside and Sunset. They have a 360 view of the water. I have 0 view, no golf course, no mountains, no water, not even a peekaboo view. And they're comparing me to these comps that are, number one, twice the size of our lot, okay? And the comps aren't right, they're just not correct.
Okay. Anything else?
I'll just try to get it all out.
Whatever you need.
Okay.
Whatever you need. I mean, you'll have time to rebut anything he says, but go ahead.
Okay, well, I'm just saying that the taxes have gone up 38.5%. That's $153 a month out of our Social Security, which we live on. The comparison, pardon?
The year.
Oh, and like the year of our mobile home, it says it's a 2011. It's not correct. It's a 2006. I brought proof of that if needed. And by their response back to me, they're saying that mine weren't used due to being part of a different adjustment based on their location, either on a golf course or a runway frontage. So you're saying me that has nothing is worth more than on a golf course? That doesn't make sense to me. That's it.
Okay. All right.
So, first thing to address was the note from the realtor. I didn't see anything on this note. It also was submitted after the deadline, so make note of that. The comps being more desirable, the comps that we used, as seen on page 7 in the sales grid there, are of comparable properties and are adjusted in the sales comparison grid to be in line with the subject property. So these are not different in their land frontage. I know on page 8, you see there was mention that the remaining 3 sales that the appellant provided were not used due to being part of different adjustments based on their location. So there was adjustments for golf course frontage, runway frontage, interior lots. With this particular area, we do try to be as as specific with our adjustments as possible. So those sales weren't used because of that, and that goes to show that we are looking at other parcels that are comparable based on land and as far as the improvement type itself. As far as the improvement, the year built on improvement being built in 2011, or we have it as 2011, and the actual year being 2006. I was not aware of that information. That information wasn't provided till now. As far as I know, there isn't anything that I saw. So if that is, that will need to be corrected. How that will affect the value, I'm not sure, because the effective age, it'll have an effect on the effective age, but I can't sit here as of today and tell you the effect on value that would have. Again, that was not information that I was privy to before this. So, however, after inputting the subject into a sales comparison grid, a lower valuation is supported. Therefore, that is going to be my new recommended value. So we are asking the board to adjust the current assessed value to land 98,000, building 550,000, for a total assessed value of 648,000.
Chance to rebut?
Oh, you,
Okay, so my turn, I
Sorry.
didn't have permission. So are you saying that the letter that my realtor wrote, you're not accepting?
ma'am, address the board.
You're not accepting?
If it came in after the time, then no.
Okay, you mailed it out to me on August 28th. That was then the 29th I received it. It's Labor Day weekend. That that Monday that I got this from my realtor, I went and sent it, and it was 21 days before the thing, because you didn't get it, but I sent it certified. And it was dated when I sent it, so it really did make the 21 days.
Didn't receive it. I don't have any extra information. Must have just gone directly.
Do you mind, Mr. Chair?
Go ahead.
Was it sent to the board and the assessor, or just to the assessor's office?
It was sent to Clayton Johnson, a Grant County
Okay,
assessor.
and he received that, but for the board to consider it, just like any other evidence, we have to have received it. It's not his responsibility to give your evidence to us.
It's got to be both.
And that's what the 21 days is. Both parties have to meet that 21-day deadline. That's the state law. That's not county. That's not anything.
I mean, in regards to this response that was submitted, yes, it was submitted after I obviously still read it, but there wasn't anything in there that would cause for a value change, regardless of it being, whether it was received before or after the deadline. I don't see, it just mentions that, kind of the same, that they just don't, agree with it based on their professional opinion, but there's no sales. It's just kind of a letter saying that there's differences in there. And again, that's all accounted for in our sales comparison grid there. So with that letter, there wasn't anything glaring that told me that our value was incorrect.
Okay. Anything else?
I just disagree, so I have to agree to disagree.
From either side?
I have a question still.
You're-
Did you speak with the assessor during this process? I mean, you brought up the fact that they have the incorrect age on your home. Did you go in and speak with the
I
assessor?
didn't notice that until
Okay,
the other day.
we encourage everyone constant communication, because there's a lot of problems can be resolved. And then your value, you have 551,000. Where did you come up with that value?
I based that on what our surrounding areas were doing, where we have no view. And he's saying that it makes a difference how he adjusts properties based on where they're located. If you look on the map, you'll see clearly we're in the dead center with nothing around us versus, again, 360-degree views. I mean, that's, common sense that those are the higher, lots desired. We just couldn't afford to buy on that lot, so,
Thank you.
Okay. This concludes the Grant County Board of Equalization hearing. The board will review all information provided, and board orders stating their decision will be issued within 45 days. If either party disagrees with the board's decision, they may appeal to the Washington State Board of Tax Appeals within 30 days of the mailing of the board order. We're in recess till 11. Good morning. Today is Thursday, October 2nd, 2025, and we're on record with the Grant County Board of Equalization, and we'll be hearing petition number 2024-007, parcel number 50093-170747019, represented by Mary Shipley / Huberto Law Offices. Jerry Huberto is here. The assessor's office is represented by Darren Hine, who is also in attendance. Please silence your cell phones and note these hearings are being recorded and will be posted to YouTube once the order has been issued. Mr. Chair, the board is convened and the hearing is open.
The hearing today is regarding the true and fair value set by the Grant County Assessor's Office. A reminder, this relates to the assessed value of the property, of your property, not your property taxes. The Board of Equalization is independent of the Assessor's Office. We are 3 citizens appointed by the Grant County Commissioners and trained by the Department of Revenue. Today's board is myself, Jim Brakebill as chair, Mark Steinmetz as vice chair, Jerry Gingrich as a member, and Rosa Decker is also here as a member, but she's not a voting member. We have reviewed all evidence presented by both parties. This hearing is only to provide any additional oral testimony. No new evidence may be submitted at this time. Remember, everyone's time is valuable. Please try to keep to the timelines. Please address the board only. To both the appellant and the assessor's representative, swear the testimony you're about to give is the truth?
Yes.
Okay. The appellant will go first, so go ahead.
Thank you. Hey, stand, sit. Does the
Sit.
board have a
Sit,
preference?
yeah.
You okay? Okay. So formality, wearing my jacket, not used to that. So,
Before you go,
yes.
we have all your exhibits listed, so you have to give us a bit of time to get to each exhibit if
You're going to refer to an exhibit.
Perfect. And can I ask a question? Have you had a chance to review the stuff before today? So you've already gone through. Okay. As I indicated off the record before we began, I'm somewhat unfamiliar with this process. So bear with me if I'm doing something wrong. Feel free to throw something at me or holler at me. Okay. I'm assuming it's I start, they respond, and we get a chance to maybe answer some questions as necessary.
There's a back and forth.
Perfect. Okay. So if you have questions, in fact, I'd like to focus just on that mostly as you've gone through everything. I've looked at it relatively fresh, as I'm sure all 3 of you have. Another attorney in my office who's no longer there as of Friday, was his last day, was handling this matter. So I took it over yesterday, trying to go through this and review it myself and get up to speed, of course, about what the issues are. So it really is fresh, just like I suspect you guys have looked at it. And quite frankly, I'm surprised and concerned as to why we're here. And I suspect maybe I'll get a chance in the back and forth to find out what the response is as to why. From what I can tell, and you've seen the maps, is small parcels of property, obviously, and it's contiguous property. It's current use on the north, south, west, and I believe the east is the lake. And so it's farming property all around. And there's a roadway that cuts in between. And this roadway is used for the farming on both the north and the south sides of it as well. And somehow that small parcel is what's being segregated out. And I believe I'm going to hear the allegation is, well, that parcel is strictly the roadway. And I just quite frankly can't see how that's the case. And if it is, it's contiguous, it's more than 20 acres. Quite frankly, it shouldn't matter. It's owned between the north and the south property is owned between family members. Both parcels were inherited from my client's mother when she passed away, and it's her brother that owns the other one. There's no dispute that the property is being farmed. So in all summary, there's a couple of issues too as far as the statutory timelines and the notices, which I'm sure all three of you noticed in the materials, and I'm happy to answer those questions about the dates if you would have them. But otherwise, the bottom line of this is the property is contiguous. It's over 20 acres, so it certainly qualifies as current use classification, in my opinion, and my clients. Or secondarily, the county failed to follow the statutory notice requirements. So either or both of those are sufficient to move this forward today. So as I indicated, I'm happy to answer any questions you have, but if you've read everything, I don't want to belabor it and make your day any longer, so. Save a couple moments in response if I can.
Obviously, you guys have reviewed my response to the petition. This is a 0.39 acre parcel that was sectioned off specifically for a driveway to the appellant's home. It was in reval. I physically inspected the property, the home, and had to drive down the driveway to get there. If you look at page 4 of my response, you'll see when the audit was mailed out to the appellant. After she received that, she came into the office on January 10th, and also in my response, she signed the fact that it was a driveway not being leased, and signed it on January 10th, 2024. That's why we removed it from current use. The contiguous, it's not being used for getting combines out in the fields. It's a driveway to a residence. She signed it. That's where we're at.
Anything else?
Not at this point.
Any rebuttal?
Yes, thank you. If you can pull up Exhibit G, I think that's probably the clearest picture that we have of this, so we make sure. I'll give you an opportunity to let me know when you have it. I know that you probably got it organized on the computer differently.
Got it, Marge?
Yep. There.
All right, thank you.
Sorry, I didn't know you were waiting for me.
Oh, that's okay. I just want to make sure we're on the same spot, and
Yep,
know,
I'm there.
hard copies, it takes me a while to flip through to get the right one anyway. So as you see the strip of roadway we're talking there, I'm not sure if we can rely upon this Grant County web map, but that's clearly what the assessor's office has done. They're looking at a map and saying, oh yeah, this must be the roadway. But if you actually look at the survey and you do the math, the 24 was at 24.7 feet north of the house. It encompasses some of this farm ground that is being farmed. And yes, ideally it's asphalt, right? So it's asphalt as opposed to a gravel driveway that we're used to seeing in between these two smaller farm parcels. But to think that this roadway and this access isn't used to be able to farm that property is naive at best. It clearly is. There's no other access to it aside from the West Shore. And I'm not sure the last time any of you have been down West Shore, right? And it's been a while for myself as well, but it's a busy roadway. You can't access the farm right off of that. Just because it's smaller parcels doesn't mean that it's not being used during that roadway. Anyways, this property has always been current use. It has been farmed continuously. It's been owned by the same family this entire time. So I think if you look at that picture, it helps speak volumes about what's going on here. And the assessor can't just use some map and say, well, shucks, I think that encompasses the roadway. Do any three of you have any questions specifically about the position taken?
I don't have any questions. Aaron, do you have any rebuttal?
Yeah, we reached out to the surveyor, which you'll see the email chain on page 11 of my response that came from our deputy assessor Amy Perez, who at that point in time was in charge of current use. And he stated that the assessor looks correct to me after he reviewed the plans. You'll see that on page 13 after the 3-page conversation about, okay, what is this? Why was it sectioned off? What is the purpose of sectioning this off? 0.39 acres for ag being sectioned off. What's the purpose of that? It's for a driveway. And the surveyor that did that agreed with us after reviewing his work. So it's not just us looking at our GIS maps. We contacted the surveyor and he agreed with us.
I think it's important to note as well that this parcel was split up. Prior to it being split up, that little sliver of land didn't exist. It was split up to give that portion of land to the appellant. And so the land was and is on either side of that continue to be farmed. In fact, both sides of the driveway are leased to the same person and are farmed. The purpose of creating that was initially, if there was no intent to change anything, then, and this is just an outside view, what is the intent in creating this sliver of land? If it was just fine where it was prior to, however, the will and testament was giving that southerly 40 feet to the owner of that parcel, that strip, as seen on Exhibit G of the appellant's information, as well as the parcel below to the appellant. It not only do we have the determination or the review by the surveyor who did the survey, the paperwork filled out not stating that any of the ground would be used for farming, that it was just driveway. That was filled out in our office and given to us. Our determination based on that, as well as the additional information received, is what led to that determination that the parcel of land, as it no longer, although it is contiguous, from all the information we received and the information that's here, was not an integral part of the farming operation. That driveway to the house was not an integral part of the farming operation. And so that is the reason the determination was made to remove it from the current use program.
Yeah, I would love to, thank you. And I appreciate the back and forth that you're referring to, so this is helpful to know. I recognize this isn't a courtroom where I can't stand here and object about hearsay and all the other rules of evidence that apparently don't apply, right? But it's still, the concepts are the same, that the assessor says we're relying upon some email that was in their response. I've read that email, quite frankly, I didn't know what the purpose of it was, because it says, now Amy Perez's email to this Seth Bishop, who is, I'm assuming, is the engineer that we're referring to, goes on and says, I removed her from current use due to that piece being in the driveway and not being farmed since it is concrete, and she has appealed that removal, so I need to make sure that Pam mapped it out correctly in 2021. And then, hi Amy, an appeal, question mark, and then apparently, and maybe mine's not in order, or maybe that I didn't get the entire string of email, which is probably most likely. It says, okay, no worries, the assessor looks correct to me, but here are the AutoCAD drawings. Like, since when is that enough to justify what's going on? It's not. This woman's little strip of roadway here that they say she signed off on. So I look back at this petition here just moments ago, they say she signed. As you can see from the materials, clearly Ms. Shipley is confused about what's going on. Otherwise, she wouldn't have come and hired our office and wouldn't have addressed it taken it to this point. She's confused about what's going on. She thought she went and addressed this with Ms. Perez in the office that day in January and left thinking it was resolved. And now here we got some signature of saying that it's a driveway and somehow that she acquiesced that this is the case. Obviously, there's no meeting of the minds. The parties didn't have the same vision of what was going on. Mind you, the only thing I haven't heard as well is I didn't hear a response to the statutory timelines and the notice requirements. I haven't heard anything. I didn't see anything in this response that was filed in writing that they followed the rules correctly. I haven't heard anything in response and argument today that they followed the rules correctly, because quite frankly, they haven't. And as my opening statement indicated, I said, listen, there's this reason it shouldn't be included, or this reason, either or both, only one needs to apply. And so we can't overlook the statutory requirements that were not followed. And I think that is an absolute bar to what they've done as well. So, I can go through those dates, but again, I don't want to belabor it. I know you guys have been here all morning, so I'm happy that those dates are set forth in our response. Maybe we'll get some response now from the respondent about the statutory guidelines. Go ahead.
We're happy to, I've got
Can
Amy
I speak to
Perez.
that? Amy Perez, Assessor's Office.
But do we need to swear in? Probably we do. So do you, as the assessor's representative, swear the testimony you're about to give is the truth?
I do.
Okay.
So when Mary Shipley came into our office, I helped her. I helped her fill out the documentation. There was no indication that she was confused. I told her, based on the information that was provided when she started her short plat or whatever plat it was with the planning department, she was notified by Pam's instruction that that piece would need to come out of current use because it was in fact a driveway. When she came in, I spoke with her at length. I helped her fill out the paperwork. She knew that it was not going to stay in. When I am auditing or sending out any kind of documentation for current use, I do not need to send out a certified letter. Not until my first response goes unanswered. Then I'm required to send out a certified letter with the same information. If that is not answered, I am to send out a notice of intent to remove the current use classification by a 30-day window. If that is not answered, then I go ahead with the removal process. So as far as not following rules, I beg to differ on that one. I'm a very stickler when it comes to rules. So when it was removed, the removal is recorded with the Grant County Auditor's Office. Therefore, she is notified through that process. And all the training and Department of Revenue trainings I've done on current use, that is sufficient, that a lot of counties do.
Thank you. And let me be clear, I'm not indicating or trying to insinuate whatsoever about Ms. Perez or anyone else. There was some kind of malicious intent here. I don't think that was the case. I'd be shocked to think that was the situation. Nonetheless, rules aren't followed, and we set forth in our response as far as the timelines. So in timelines and the statutory factors, so specifically RCW 84.34.108, subparagraph 1DI, and then of course 84.34.121, and then going on to the WAC code, WAC 458-30-27003A. I know I'm going through those fast, but you have it all in the material. I just want to get on the record that those are the issues. So there's only one request for information that I'm aware from this file that was sent out. That was on December 5th, 2023, had a response date of February 4th. My client, Ms. Shipley, did respond. I don't think there's any dispute. Did she do it in a written form? No, but she came into the office and clearly spoke to Ms. Perez as she indicates. Obviously, what Ms. Shipley says happened in that conversation, what Ms. Perez said happened. I recognize that two people can have different versions of events from the same conversation. So again, I don't believe there's malicious intent on either side, but nonetheless, they have two different perspectives about what was said. Ms. Shipley attempted to provide the information to Ms. Perez concerning the property, continuing qualifying for FAU classification as she sets forth in her petition on her version of events. I don't think it's disputed that Ms. Perez confirmed that this Clint Peters was actually farming the property. She was aware of him, knew that he was farming the property north to south. Based upon this interaction, Ms. Shipley left and thought everything was fine. So this is why the notice requirements in the statutes, the WAC codes are so important, because then it gets through that whole confusion, right? Like if you get notice, then you wait, Ms. Shipley left thinking everything was fine. Once she gets the notice, she realized, oh wait, I was mistaken. It is not fine. I need to go further look into this and deal with it. And that's why those are so important. They weren't followed. So they failed to send the second notice to Ms. Shipley by certified mail, return receipt requested, which I disagree about whether it's required because the WAC code 458-30270, as I set forth.
Which exhibit are you referring to?
The WAC code, is it in the exhibits?
Well, if you're gonna give it to us, we need to see it.
Okay, well, it was listed in the petition. I don't know if it was printed off here. Let me find it for you in a moment. See if it is actually included. On page 1, the RCW that I cited is addressed. Let me find the WAC code, which should go down into page 2. Okay, then on page 4, that's where we start to get the statutes that are cut and pasted, copied onto that argument. So you can see starting on page 4, we talk about 84.
Page 4 of which exhibit?
Page 4 of our petition. I'm not sure how you have it
The
organized.
first part of the petition before Exhibit A.
Thank you. Yep. And my copy is listed with the pages and the exhibits behind chronologically, but. And then the rest of it reads such as a memorandum with court that has the rest of it listed out and described with case law and so forth. So it's within that first factual narrative context of the petition. So I haven't got yet to see if Mr. Bevere attached the actual code printout as an exhibit, which I don't think he did. I think he just referenced it into his narrative content. I can help you. I think if you look under C paragraphs or page 7, that's probably where the heart of what I was just referring to is addressed, because that's the WAC 458-30270.
Find it.
Bottom of page 7, if that helps.
Yeah, it's on page 7.
Yeah, I've got it. See?
Thank you. So as I was indicating where I left off, I don't believe the procedures were followed, and my reading of the statute and the WAC code means that's an absolute bar given what we're doing here today, on top of the fact that it's been farmed by their family this entire time. I think that's break it down from those simplistic principles is it's been farmed and operated that way forever. And clearly this 24 feet, even if you look at the roadway itself, if we're going to take that on face value, it's bigger. The 24 feet is much bigger than that roadway. I mean, you can see that just from the pictures itself. So anyways, I don't want to overlook the statutory timelines and responsibilities because, again, nothing against Mr. Perez that it was intentional or malicious. It wasn't done. So.
Well, I'm at a little bit of a disadvantage because I don't know what he is referring to. If he is referring to the audit process where you have to send a set of certified second letter, that wouldn't have been needed because she came in with her first response and I helped her fill it out. So I wouldn't have sent her a second current use audit certified because she answered the first one within that window. He is correct. She came in January, wasn't due till February. So there would be no reason for me to send out her a second current use audit saying, hey, I didn't get this. That's typically how it goes. So I'm, like I said, I'm at a little bit of a disadvantage because I don't know what's being that I didn't follow the rules correctly? Is it the current use audit, a second notice? Like I said, would it be needed because she brought in her current use paperwork. I helped her fill her out, she signed it, we chatted, all that good stuff. If it's the removals are notified through the auditor's office because the removals are recorded with the Grant County Auditor's Office. That documentation is directly sent from the auditor's office after it's recorded.
Anything else?
Sorry, I gotta take my glasses on to see distance and take them off to read, so. It's getting old hard. No, and again, I really want to make this clear that it's easy for us to sit up here in hindsight on our pedestal, obviously, and look at these statutes and the WAC codes and say, okay, let's check the boxes, right? Because that's my job as attorney to go through and do, and that's how we make a living, not just these things, other things. It's our job to go through and check the boxes and see if things are done. It doesn't mean it's easy for everybody to know those boxes on an every single basis. I can't stress enough that I don't believe that Ms. Perez thought she was doing anything wrong. Nonetheless, here we are, the deadlines, that the notices weren't followed. And it's clear from this, what's said on the petition as well as our comments from Ms. Perez this morning, that it wasn't followed.
Anything else?
I just wanted to say deadlines and following deadlines and all that. She had 30 days to appeal that removal, and that deadline has been far past and too. So like I said, I don't know what deadline he's talking about, so all I can tell you is what I know about deadlines through Department of Revenue that I have to follow. I am mandated through Department of Revenue of what I can do and what I cannot do, and I do take those steps very, very seriously. So I just wanted to make that clear. And I don't like denying people. I don't like removing people. I try to be fair and consistent and helpful and reliable. So I do apologize if there was anything that I may have said to her to make her feel uncomfortable. I didn't think so, but I do take what I do very seriously, and I believed I followed the rules 100%.
Thank you. Can I make one last comment? I do want to point out, this is a woman that got this property along with her brother because she lost her mother. It's something she's somewhat been involved with as a kid, of course, but she inherited it from her mom. There isn't any ill will meant from Ms. Shipley, but clearly we have to have some kind of compassion, understanding about how this works. Everything was always taxed one way, and then all of a sudden it's being ripped out from underneath her in one section as to why. And she has every right to find out, well, what's going on. And she believes it was incorrectly done, and that's what we assert today.
Okay. Right. Mark? Unless you have any questions?
Nope, I have all mine were answered.
Okay.
Okay, this concludes the Grant County Board of Equalization hearing. The board will review all information provided, and board orders stating their decision will be issued within 45 days. If either party disagrees with the board's decision, they may appeal to the Washington State Board of Tax Appeals within 30 days of the mailing of the board order.
Okay, well, this is for Thomas J. Sokol, parcel number 150-699-000, and Marie Rashko is the named of the agent, and we're discussing the good cause waiver. And we have Matt Hope and Amy Perez in here.
So it was a good thing that I went back and checked, because was mentioned earlier that there was an intent to remove sent out. She requested removal of the parcel due to the 2-year death clause at no penalty, no back taxes. And I've got Amy here to for her information as per the meeting she had with the appellant as well as her son and attorney discussing process and what would be done. So if you want to just let the board know what the reason for the discussion was and why it wasn't able at that time to stay in, it wouldn't have been able to stay in the program at that time based on the contract that was there.
Okay, and there was only 70.9 acres that was in current use. So what happened was we got a solar lease for a number of properties, and I sent out requesting information regarding that, how they're gonna continue to farm, what's that gonna look like. And so when she called me, she said that, that the CRP contract had expired. And I said, okay, well, I don't know enough about the CRP program through the USDA. If the solar lease, and I don't know how that works, so you're gonna have to contact them. And she said, well, the last time we had something removed, it almost bankrupted me. And she said, you know, that Mr. Sokol had passed away. And so we chatted about that for a few minutes, and I told her there is a clause in the RCW that states if a 50% owner is to pass, you can remove that within the date of death, within 2 years, and it would be zero back taxes, zero interest, zero penalty. You would just get out free and clear. And she said,
managing the 50% partner.
yes, they have to be at least a 50% owner, and he is 100%.
Okay.
So it works perfect. She said that was great. I sent her the notice of request to remove. I told her I would need that information filled out along with a copy of the death certificate because that is required. And everything was fine. And then I got a call from her son, and her attorney wanting to go over it again. And she brought up that I had told her something about not being able to have a CRP contract with the solar lease. I said, that's not what I said. I said you needed to contact them. That's not my area of expertise, so I don't know. All I can tell you is on the current use status, you either have to be one farming, enrolled in a CRP contract for this many acres, and I need a copy of that. But we had discussed, based on the information you provided me, saying that the last time you were removed, it almost bankrupted you. So I gave you another option to be able to avoid any monetary taxes being paid back and maybe lessen the burden. And so all the attorney was in agreement. She was in agreement. Okay, yep, we're going to keep it out. And that was the best course action. And then this happened. So.
And during the initial conversation, I was unaware at that point that the parcel had already been removed as part of that clause. And so I went back and talked with Amy and refreshed even further the information. So my initial first contact from the appellants was before I even knew the parcel was out. So they were talking about being removed. I let them know, well, if we've got information saying whether it be CRP, then yes, get that to our office. That would be sufficient to not be removed. Parcel in question at that point was already removed based on the information, and it was a request from the owner to remove, a signed request. And so I wanted the board to be aware of that information because that plays a part in this process and information that needs to be understood as part of this process. This wasn't we sent out an intent to remove.
Go ahead and finish.
An intent to remove and then removed the property, and now there's an appeal. They requested removal from.
So my question is, at this present time, is it currently removed at their request?
Yes.
Yes. Yep.
And the problem lies is if we put it back in, she will never be able to use that clause again. And that's what I explained with the attorney and her son. And so that's why we were all in agreement because of the financial burden, because this is thousands and thousands of dollars that, I mean, basically was lost revenue for us. But there is that clause because they state if your partner passes away or 50%, you know, it's to lessen the burden during those difficult times. And so that's why I suggested that option.
I don't have any further questions.
I have a question. So had she not taken it out prior, would you still found that she needed to be taking it out?
If they would have supplied, which again, our office still has not, the CRP contract is a part of the reversal, or the good cause late filing. It is a part, it is information that's there, but our office still, to this day, has not received a copy of that CRP contract. So it would have been removed. We would have sent out an intent to remove, and it would have been our intent to remove it had they not supplied that. And so then there would have been communication back and forth, but because we had that request to remove, it was removed based on that information and no need for further follow-up on that. So had we had the CRP contract, it would have had enough information to stay in the program but again, we have to receive that because we have to verify that it is in fact following the guidelines laid out by statute. So,
For the record, again, you talked with the attorney understood that they were out of the,
Yes.
okay, all right.
okay. Anything else?
I think that's it.
All
Thank
right,
you very
thank
much
you.
for your input.
Thank you.
Thank you.
Let's
Have
go
a good day.
Yeah.
Say goodbye.
Maybe he'll let me run out now.
Go ahead and take us off.